We welcome you all on behalf of Beyond Law CLC. And amongst us, we have Mr. Manokaran, a lawyer who has been on our platform already twice, and his sessions have been well received. As such, on the popular demand from the participants who have been watching us on the Facebook, as well as the platform, including the YouTube, we thought that land acquisition is a proposition which invariably boggles the mind of large number of young lawyers and the professionals. And the scope of understanding the land acquisition is extremely large. There are a large number of judgments, how to do assessment, what is the manner of acquisition, because it's related to everyone. Not only the lawyers and professionals, but the persons whose land is acquired for different issues are also quite keen to understand the nitty-gritties of the land acquisition. Before we proceed, and amongst us, we have a High Court, Punjab Haryana High Court, Justice S.D. Anand. We welcome him, and we are unmuting him before we ask Mr. Manokaran to formally start and give his insights on overview of land acquisition and way forward. Over to you, Justice S.D. Anand. It has always been a pleasure appearing before you as a lawyer, as well as your insights given on the platform of Beyond Law CLC has also been well received, the manner in which invariably our sessions are being done. Sir, yes, sir. Over to you, Justice S.D. Anand. So you will have to unmute yourself. Unmute, sir. That right button. No. Yes, sir. Over to you. It's unmuted.
Are you asking me, Mr. Vikas?
Yes, sir. It's audible. It's audible.
Okay. Okay. See, by and large, land acquisition is taken to be a very dreary type of subject. But as I'm given to understand, Mr. Manokaran is going to make it highly interesting. Highly interesting. And we are going to have, I believe, a very illuminating and educative discourse today. And that's why I logged in, to be able to have the advantage of hearing Mr. Manokaran and participating in your deliberations. Rest,
Mr. Manokaran?
After
yes.
concluded.
Yes. Good evening to one and all. I wholeheartedly thank Honorable Justice S.D. Anand for being here, and also I thank Mr. Vikas, a gentleman lawyer, who gives me this opportunity to present my experience in the field of land acquisition. Besides that, I wholeheartedly thank Mr. Justice S. Nagamuthu. But for him, definitely I would not have been present before you in this platform. Therefore, I thank all the great personalities who are present here and also given this opportunity to share my views on the land acquisition laws. You know well, the Act is only a newborn baby. It is 2013 Act. It came into effect on 1/1/2014. Therefore, I don't find mentions of this new Act, 2013 Act. Anyhow, I have seen almost many of the provisions in the old Act are paramateria simply incorporated in the new Act also, besides adding many provisions in favor of the landowners. After the Constitution, under Article 19(1)(f) and Article 31, right to property was recognized as a fundamental right. So, right to acquire, hold, and dispose of the property was originally treated as fundamental right. Then subsequently, after nearly 25 years after the Constitution, on 26/1979, by way of 44th Amendment to the Constitution, both these articles were deleted. 31, Article 31, Article 300 was inserted, whereby still the provision reads that no one's property can be deprived of except by following the procedure established by law. So as on today, it is not a fundamental right, whereas it is not only a constitutional right and also a statutory right. So right to property as on today is not only a constitutional right and also a statutory right. Now the courts have started recognizing it as part of a human right. Therefore, the origin of the right to property has been given different color under different article, and the courts have evaluated in different form. You know well that right to property, it has a strong linkage between the person's social status in the society. That is why realtors used to say, investment in the land is the best investment in the world. Therefore, always land has its own unique value. You know well that in our country, it's a land deficit and people surplus. It is a land deficit, people surplus country. We have only 3.3 million square kilometers of land to accommodate 130 crores of people. Land is only static, it is not dynamic. So irrespective of the population, we have to accommodate ourselves within the four corners of 3.3 million square kilometer. And it is not a land is not a commodity. It has its own social, it is almost like an economic asset of an individual. Therefore, a person's social status is being tested and decided on the basis of the land. That is why the person who lost the land is being called as a land loser, even though the act says land owner. The Supreme Court has coined the word land loser in 2010 7 SCC 129 by saying that the person who has been deprived of the land can't be land owner, he should be land loser. In fact, this act, earlier act, Land Acquisition Act 1894, came into effect on 1/3/1894. Almost it has lived its life for more than 120 years. In fact, even after the Constitution, it was originally introduced by the British. Then thereafter, even after the independence, the independence India has completely adopted this 1894 by way of this act called Indian Independence Adaptation of Central Acts and Ordinance Order 1948. So virtually, even after the independence, nearly for 60 years, the existing, the repealed enactment was in force. The earlier enactment was very draconian and is a very brutal act. No doubt, the power of acquisition is traceable under the doctrine eminent domain. Such power is given to the sovereign government to acquire the private person's property for the public cause, even without the landowner's consent. It is a kind of political privilege given to the legislature. And this eminent domain power, which was given under the old act, was being misused. And because you would have seen a lot of acquisitions were made and the lands were kept idle for decades together, and the compensation were not paid to the persons displaced. And the authorities used to select the particular set of people for the purpose of deleting their land from the acquisition process. Therefore, this has caused so much agony to the agriculturists. In fact, the old act was protested all over India in different form whenever the lands were acquired for the public purposes. This 1894 act has many perils. Like there was no proper procedure for payment of compensation, and even compensation paid by the land acquisition officers were very, very low, and the landowner, namely land loser, has to fight for 2-3 decades for the purpose of getting even reasonable amount as compensation. Ultimately, when he gets that compensation amount, that may not have any value at all, because by the time it would have crossed more than 20-30 years, and there was no provision for rehabilitation or resettlement process, and further there was no safety for this agricultural, that is food crops, and there was no damage being paid to the crops, there was no damage being paid to the properties damaged at the time of taking possession, and virtually the landowners become landless poor farmers. And in fact, in a casual manner, in one judgment it was said, even the collector used to pay 30,000 for a buffalo which died in some natural calamity, whereas the landowner who has lost his land will get only 20,000 per hectare. So this was the position for buffalo. The government got paid 30,000, whereas for land for 1 acre or 1 hectare only 20 to 30,000 was paid. This was the position. You would have seen number of cases, almost not number of cases, almost invariably in all cases, the value fixed by the land acquisition officer was very, very low. Invariably in all the matters, when on reference, the amount was enhanced and further enhanced by the High Court and Supreme Court. It shows that the land acquisition officers had the tendency to fix only very meager amount. In AR 2004, Andhra Pradesh, page number 1, full bench judgment. Every one of us must read the judgment. In fact, the full bench of the Andhra Pradesh in AR 2004 AP1 has thoroughly examined the agony undergone by the farmers and held that in our country, most of the land losers are rustic villagers, and they had no knowledge about their right to make reference under section 18. Therefore, in this set, full bench said that in all the land acquisition cases, the collector, who is an authority under the act, has to apprise and put the landowners on notice about the provision which is available for claiming enhancement, even after knowing that provision. If the landowner has not made any application, the collector has to get an express consent from the landowner for the purpose of waiving his right to claim enhanced compensation. So that is why you would have seen many applications have been moved under 18 reference with belatedly. So the landowners had no knowledge about the provision which is available for the purpose of making the seeking enhancement under section 18. That is why the full bench has gone to the extent of saying it is the duty of the collector to put the landowner about the provision available under the statute, particularly when acquisition has been made compulsorily. In fact, the scope of this eminent domain power has been elaborately discussed by the Honorable Supreme Court in this West Bengal case. Lands were acquired for Tata Motors, that was ultimately dropped by the Tata Motors itself. The said judgment reported in 2017, 11 SCC 671, 2017, 11 SCC 671. No doubt there are two views. Therefore, the matter has been referred to a larger bench. But in the said judgment, the Supreme Court has thoroughly examined two aspects. One, how public purpose has to be ascertained. One. Two, how the eminent domain power can be exercised. These two terms have been elaborately discussed in this judgment. Therefore, according to me, this judgment is enough for the purpose of understanding the entire scope of public purpose as well as the eminent domain power. Even the repealed enactment, even for public purpose, no clear-cut definition was given. The public purpose was very vague. It was interpreted by the authorities to suit their convenience. Therefore, the acquisition made under the earlier enactment was unable to meet the changing situation of the country. That is why legislatures thought to amend the existing laws and introduce a new enactment. In fact, much before the amendment was introduced, we should thank to the judiciary, because at least in 3 or 4 judgments, the Honorable Supreme Court has strongly deprecated the practice of acquiring the land indiscriminately, even without ascertaining the need or necessity and the actual extent required for the purpose of a particular project. Therefore, the Supreme Court has strongly come down and deprecated the authorities from acquiring even the fertile lands for industrial purpose or for this housing colonies. The first and foremost judgment of the Honorable Supreme Court in 2010, 7 SEC 179, 2010 7 SEC 179. I have circulated my notes to Mr. Vikas. In that I have given the entire details. That is the first judgment in which the 3 justice bench of the Honorable Supreme Court, authored by Honorable Justice R.V. Ravindran, his lordship has thoroughly examined the agonies undergone by the agriculture in India, and he has suggested various reforms. In fact, he has categorized type of acquisition of lands and how the grievance of the farmers can be alleviated, and in fact, suggestions have been given to rehabilitate the displaced families, and also to give a portion of the land for the purpose of developing it by the land losers. So only in this case, the Supreme Court has used the word land loser, 2010 7 SEC 179. In fact, this judgment is the basis for the legislature to introduce the new act. If you read this judgment, you can find that many of the suggestions given in this judgment is being carried out in the new act. In this case, the Supreme Court has given 3 categories of acquisition. One, the acquisition for the benefit of general public and national interest, namely highways, water bodies, water canals, dam. These are all for the benefit of all the public at large. Therefore, no one can have any grievance in respect of the acquisition made for this purpose. Second category, land acquisition for economic development and industrial growth. That is for industrial purpose. Even for this purpose, all the public may not have any direct beneficiary under the project. However, indirectly it gives some kind of benefit to the by of employment opportunities to the citizens. Therefore, this is also to some extent tolerable. The third one, acquisition for the purpose of planned development in urban areas. That is for housing colonies. Only for in respect of this acquisition, Supreme Court has said that you cannot rob the Peter and pay to Paul. This was the word used by the Supreme Court in this judgment. You cannot rob the Peter and pay to Paul, because virtually you are depriving, you are forcibly acquiring the person's property on payment of some paltry sum, and you are selling it for third parties for a larger price, and thereby you are virtually getting benefit. So in such circumstances, Supreme Court has suggested that in a case of acquisition for the purpose of housing development of urban areas, you should acquire, you should make use of a portion for the purpose of developmental areas. Then suppose take an example, out of 10 acres, 2 acres have been used for the purpose of road and common public purposes. The remaining 8 acres are there. So out of 8 acres, you can give allotment to 1 acre or 50 cents to the landowner, so that he will develop his own land for his own interest. Namely, if the entire colony is developed in 8 acres, then he can make use of 50 cents or 1 acre out of it, and he can convert it for the purpose of carrying on some business or for his own residence, so that his property also will get more value along with the development which has taken for in respect of the lands acquired. So this was the suggestion given by the Honorable Supreme Court in the said judgment. In fact, you see, this suggestion was given mainly on the ground that the time taken in the course of litigation for the purpose of awarding compensation. Take an example, a land was a 3 acre of land was acquired in 1990. Then land acquisition officer normally would fix 1/3 or 1/4 of the market value prevailing at that time. So take an example, out of 3 acres per acre would fetch 1,50,000. He would give an award for a sum of rupees 1,50,000 for the entire 3 acres. Then land loser has to file an appeal before the reference code. Then the reference code, namely civil code, may accept the case of the landowner. Then it will enhance it to 50,000 to 1 lakh per acre. Then again he has to move the High Court. Then High Court has to take note of the entire land location, developmental activities, and all other potentials. Then ultimately High Court has to fix 1,50,000 per acre. Ultimately, this litigation would have taken nearly 10 to 15 years. Just imagine, this amount had it been given to him in the year 1990, he would have invested in some other manner, and he would have compensated the loss caused because of the acquisition. If the very same amount is paid after 15 years or 20 years, what is the use of it? In fact, even the amount paid in piecemeal will not fix any fruitful result. Ultimately, he has to suffer. Virtually, the landowner is deprived of his livelihood, deprived of his social status. So that was the view expressed by the Honorable Supreme Court in the said judgment. Particularly, paragraph 148 to 158, judgment of Supreme Court in Kondu Ramasamy, reported in 2010, 7 SCC 179. It's a classic judgment of Supreme Court in favor of the land losers. The next judgment is Noida, Greater Noida Industrial Development Authority case, reported in 2011, 3 SCC 375. 2011, 3 SCC 375. In this case, Supreme Court has said that land is almost a mother to the person who has been displaced. So, if the land is acquired, not only the present generation of the land loser and also his future generation will be deprived of his right to livelihood. This was the view expressed by Supreme Court. Therefore, Supreme Court has deprecated mindless acquisition of fertile and cultivable lands for the purpose of for developmental activities. And the concern expressed Supreme Court is by taking note of the serious food crisis to be faced by this country after 10 years or 15 years. This was the concern expressed by Supreme Court in this judgment. Then the third judgment of Supreme Court is 2012, 1 SCC 792, 2012, 1 SCC 792. In this case, the Supreme Court has said that owning a house is a lifetime dream of every person. House is a castle for every human being. House is a castle for every human being. An ordinary man would invest his lifetime earnings and savings for the purpose of purchasing a plot, and he would construct a house for his own. It gives him a kind of a security to his family. Therefore, if even a small portion of the property acquired, purchased for the purpose of construction of house is acquired for the purpose of some developmental activities, just see the agony undergone by the person concerned. So that is Supreme Court. This kind of unjust, arbitrary and unreasonable acquisition to deprive a person's right is not permissible in law. This was the view expressed. Then finally, 2015, 14 SCC 327, 2015, 14 SCC 327, Bhusawal Municipal Corporation, Bhusawal Municipal Council case. In this case, Supreme Court has elaborated the right of the agriculturists, and Supreme Court has gone to the extent of saying that fundamental right of a farmer to cultivate his land is part of his livelihood under Article 21. So, agricultural land is the foundation of sense of security and freedom from fear. Assured possession of and lasting is a lasting source for his peace and prosperity. Therefore, there is a strong linkage between the land and the person's status in the social system. This was the view expressed. In fact, Supreme Court has gone to the extent of saying that a farmer's life is a tale of continuous experimentation and struggle for existence. Mere words or visual can never convey what it means unless a person experiences it. So this was the view so of the Supreme Court, and Supreme Court has gone to the extent of saying, if you have not paid the compensation then and there, then land should be restored to the landowner. This was the view expressed in 2015. So these are all the judgments of the leading judgment of Supreme Court, which prompted the legislature to rethink about the existing Land Acquisition Act 1894, and thereby the new act came into force. In fact, earlier, before this new act came into force, there were two bills were introduced. One for land acquisition, another for rehabilitation and resettlement. Then ultimately, 39th and 40th report submitted before the parliament, both have been clubbed together, and a new act has come on 1/1/2014. Honorable President has given assent on 26/9/2013. 26/9/2013 Act came into force from 1/1/2014, and I would say this act, new act, is almost farmers friendly. If I am going to give you the overview of the main provisions of this new act. If the provisions of the new act is applied strictly and scrupulously, then according to me, no acquisition is possible hereafter. In fact, I would say this, the very purpose of this act itself is only for the purpose of discouraging the acquisition. I would say this is only for the purpose of discouraging the acquisition. Yet further, I would say this almost this new act, because only few provisions have come before the court for consideration, not all the provisions, and so far no acquisition made under this provision has come before the court for testing. Therefore, it is only a newborn baby. It is yet to see the. Therefore, this provisions of new act is almost death knell to the acquisition law. So acquisition is not at all possible if the provisions of the act has been given in strict application to the acquisition process. The reason is that before acquisition, there is a section 2(1) of the new act has clearly defined the public purpose. Unlike the earlier 3F, this public purpose has not been left to the discretion of the authorities. Public purpose has been well defined under section 2(1). Therefore, no more interpretation to suit the convenience of the executive is no longer available. That is one aspect. 2, section 2(2) of the act says consent of the landowner must be obtained. They have categorized A and B. A, if the land is acquired for the purpose of a private project, then consent of 80% of the owners must be obtained for the purpose of acquisition. Consent of 80% for the purpose of private projects. Suppose the land is acquired for, that is project B, private public project, then consent of 70% of the landowners must be obtained for the purpose of private public partnership projects. So, just take an example. If 75% of the persons have given consent, 5% have not given consent, then land can't be acquired for private projects. Similarly, for public projects, even 69% of the person have given consent, 1% has not given consent, even the project can't be acquired. So this consent given under section 2(2) is the first and foremost provision which we have to celebrate under the new act. This consent has to be obtained in the course of social impact assessment study, that is dealt with under section 4 of the act. So social impact assessment report has to be prepared by an authority competent under this act. Administrator is nominated. Under this act, before acquiring the land, before issuing the notification under section 11 of the new act, the authorities have to prepare a social assessment by taking note of the land acquired and availability of the available lands available in the near vicinity, and which the acquisition is going to give on the land losses, and the crops being cultivated in that area. There are various other aspects to note of for the purpose of so impact. For that, the notice has to be given as well as and the publications in and taluk office, and in fact local bodies, Grama Sabha or municipality or town panchayat or corporation in whose area the land sought to be acquired is located should be given reasonable opportunity of hearing, because ultimately the local authority is the authority going to develop the property. The under section 4 to 9 or 4 to 8 of the new act. So social impact assessment study has to be prepared, not only giving opportunity to the public at large, that is the persons affected, and also to the Grama Sabha or the municipality concerned for the preparing not to be examined by section 7 of the act. He has to analyze. He will recommend the report to the commissioner. Commissioner is in the cadre of secretary to the government. Then the commissioner defined under the act, sorry, section 3 of the act, has to evaluate the overall prepared by assessment social assessment report, and then he will recommend it to the government. So if you take preparing this assessment, ground level administrator preparing the report, social impact assessment report, then participation of the public and panchayat, then report should be examined by the expert body, then thereafter it should be placed before the collector. Collector should place it before the commissioner, then commissioner should place it before the government. So these are the mechanisms available for the purpose of ascertaining the social impact assessment. This is exempted in respect of urgency clause under section 40. Section 9 of the act is very clear that social impact assessment report is not necessary in respect of the acquisition made under urgency clause under section 40 of the act. So this is the benevolent provision. Then after this, while assessing this social impact report, authorities should take note of food security. Suppose the food security, that is, if the multiple crop lands is sought to be acquired, or if fertile lands, fertile agricultural lands have to be acquired, then Act section 10 says the authorities should avoid acquiring multi-cropped or agricultural lands, and if there is no other way except to acquire such lands, then section 10 again says that the authorities should develop the cultural based lands as agricultural lands. So equal to that of the lands acquired should be developed for the purpose of meeting the deficiency. This was the safeguards given under section 10 of the act. Then after the acquisition, this social impact assessment study has been made, then the authority has to pass notification under section 11. Declaration has to be made under section 11. So that declaration is almost like section 4 of the earlier act. So here again, the authorities should give proper publication in the local newspaper and in the locality, as well as by of website. The sufficient opportunity should be given to the affected person to place his section of 11 before issuing declaration under section 19. The present 11 is old section 5. The present 19 is old section 6. So in between section 12, section 12, the collector has to take some steps to survey the land, identify the boundaries, and mark the boundaries, and he should ascertain the actual location and shape of the land. All these things he has to done under section 11 of the section 12 of the Act. So this has to be done in between section 11 and section 12. Then after after considering these aspects, after considering the objections filed by the landowners, spot inspection, proper combination of social impact assessment. If this section 11 has not been issued, section 11 has not been issued within 12 months from the date of submission of social impact assessment report again under section 14. Suppose social impact assessment report has been submitted before the government and it was accepted. Land acquisition proceeding has not been initiated within a period of 1 year from the date of social assessment report. In such a case, then that section 11 has to can't be issued, and fresh social impact assessment has to be prepared under section 14. So this is what is section suppose the government has decided to, for the purpose of extending the period after receipt of this social impact assessment. So this is what the provision says. Then comes section 19. Section 19, declaration, that is final declaration, is equal to that of earlier 6, has to be issued, and this should be issued within 12 months from the issuance of preliminary notification. Preliminary notification has to be issued within 12 months from the date of social impact assessment report, and the final declaration has to be issued within 12 months from the date of application of the preliminary notification. If there is no declaration under section 19, there is a deeming lapse as per section 19(7). If no declaration has been issued under section 19(2) of the Act, then automatically after 12 months the acquisition gets lapsed under section 19 clause 7 of the new Act. But however, the government is entitled to extend the period of period up to further period of 12 months, not beyond that. So 12 has to be issued within 12 months. If not, government has power to extend another 12 months. This is what section 19 clause 7 says. Then yet another before going into the other let us examine topic of the Supreme Court, that is section 24(2) first part says before 24(2), let me explain few more provisions. That is after this preliminary notification, before final declaration, besides the social impact assessment report prepared under section 4 to 8, yet another scheme has to be prepared. That is rehabilitation and resettlement scheme. That is as per section 16 of the Act. So it has to be prepared by an administrator who is equal to that of the deputy collector. He should prepare a report. He should prepare a scheme as to how these displaced families could be accommodated and how they could be compensated, and what are all the mode available for the purpose of giving rehabilitation to the displaced families. So this scheme has to be prepared before issuance of section 19 of the final declaration. So after completion of this final declaration under section 19, let me explain the section 24. Section 24 is the currently the very hot topic everywhere. Even under this act, this is the provision has come up again and again before the Honorable Supreme Court, and there are a lot of judgments have come by giving interpretation to this section 24(2). 24 reads that land acquisition process under Act 1 of 1894 shall be deemed to have lapsed in certain cases. Very caption says that deeming clause. So under certain contingencies, the earlier acquisition made under the earlier act shall deemed to have lapsed. This is what the provision reads. 24(1) says two contingencies. One, if award has been made under section 11 of, if no award has been made under section 11 of the earlier act, then award proceeding has to be done only under this new act. That's what 24(1) says. 24(1)(a). 24(1)(b) says, if no award has been passed, then if award has been passed under section 11 of the earlier act, then the entire acquisition proceedings should continue under the old act, not under the new act. This is what 24(1) says. 24(2), 24(1) and 24(2) both starts with the word notwithstanding anything contained in this act. So this to interpret that, we should ignore the other aspect, and we should take note of only this provisions alone. So that is why the confusion has come again and again. This 24(2) says that notwithstanding anything contained under section 1 of subsection 1, where an award under section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken, or the compensation has not been made, the said proceeding shall be deemed to have lapsed, shall initiate the proceeding under the new and land acquisition afresh. This is what section 4. Either one of the condition is not complied with. Namely, there are three contingencies. One, award should have been passed 5 years before the act came into force. 5 years before 1/1/2014. That is first condition. Second condition, if no award, if no compensation has been paid to the landowner. Then third condition, physical possession has not been taken. In the earlier act, only possession is referred to. Here, physical possession is referred to. So there are three contingencies. First condition, award should have been made 5 years before 1/1/2014. The second and third condition, whether to be read distinctively or conjunctively, is the subject matter in issue before the Supreme Court. One view is that R should be read only as R. Another view is that R should be read as and. So these are two views which came up for consideration before the Honorable Supreme Court. The Supreme Court in Pune Municipal Corporation, in the first judgment in 2014, 3 SEC 183, rendered by 3 judges bench of the Honorable Supreme Court, said if either one of the condition under 24(2) has not been complied with, there ends the matter. Suppose if possession, physical possession has not been taken, but compensation has been paid. Even now, the or if the amount has not been paid, but amount has not been paid, but physical possession amount has been paid, possession has not been taken, then in such circumstances also the acquisition proceedings should go. So either one of the condition is satisfied, there ends the matter, was the view taken by the Honorable Supreme Court in 2014 3 SEC 183. the almost similar view was expressed in 2014 6 SCC 564. This similar view was expressed by another 3-judge bench of the Honorable Supreme Court. Subsequently, another 2 bench of the Honorable Supreme Court in 2015 3 SCC 353, 2015 3 SCC 353, where they said even though stay was granted, irrespective of the stay granted in respect of dispossession, if this if of these 2 conditions have not been complied with, then there ends the matter, acquisition gets lapsed. This was the view referred. Then this was also followed in 2015 341. Finally comes Indur development. Even before that, these 5 judgments of the Honorable Supreme Court, which are fully in favor of the landowners. First time in 2016 6 SCC 387, Supreme Court has referred the matter to larger bench and the 353. That means whether the period has been referred to a larger bench in 2016 6 SCC 387. When that reference was pending, yet another judgment has come, that is 2018 1 SCC 733. 2018 1 SCC 733 by that is Indur Development Authority case. That was the second reference. In this judgment, 2 judges of the Honorable Court thought that the earlier view of Supreme Court in Pune Municipal Corporation requires some more consideration, and some of the important provisions were left out, and Supreme Court has taken note of the first reference made in 2016 6 and finally the matter was referred to 3 judges bench. Ultimately, 3 judges bench of the Supreme Court in 2018 1 SCC 3 SCC 2018 3 SCC 412, 2018 3 SCC 412, 3 Supreme Court in Indur Development Authority case said that otherwise, but incidentally they said that already there was a judgment by 3 judges bench in Pune Municipal Corporation. Therefore, in order to give a quietus to the issue, the matter was again referred to a constitutional bench, and finally constitutional bench in 2025 scale 34 25 scale 5 scale 34 in the very same Indur Development Authority case has laid down the law, and wherein the Supreme Court has said that R should be read only as and, not as R. So the view of the Supreme Court is that R is only R should be read only as a conjunctive and not as disjunctive. Therefore, if both the conditions have not been complied with, then only section 24(2) can be invoked by the landowners. So this was the view expressed by the Honorable Supreme Court. The Supreme Court has again said that preparation of a Panjanama by no need to record physical possession. We have seen the Act section 24 is very clear, and the Constitutional Bench has said that physical possession is only a possession to be recorded by the Tahsildar. So ultimately, the Constitutional Bench said that if compensation paid but possession taken, then question of invoking 24(2) doesn't arise. Compensation not paid but possession taken, even thereafter section 24(2) can't be invoked. So in either way, if either one of the condition is available, then 24(2) is not available to the landowner. So both the conditions must be satisfied for the purpose of deeming lapse provision under section 24(2). This is what the Supreme Court has interpreted. In fact, even this judgment, according to me, requires some more deep analysis, because an example, the land acquired under section 16 of the earlier the repeal enactment. So you have lands acquired, it is deemed to be vested with the government. So the government, once notification is issued, possession is taken under section 16, it vests with the government. So whether the lands vested with the government can be revested, or if the compensation has not been paid even after vesting, what is the remedy available to the land losers have not been taken note of under the constitution. The judgment runs to several hundred pages, so it is very difficult for us to read and understand the entire principle of law. So the penultimate paragraph, Supreme Court has given the guidelines to follow in future. And in this judgment, the interpretation given to physical possession is also requires reconsideration in future. Even the another 5 judgments or 7 judgments have to decide whether the law laid down in Hindu Development Authority requires further consideration, because there are many other issues to be addressed in the constitutional bench. We would have seen there are acquisition even under the Town and Country Planning Act. Whether it will have any bearing over this act, that there are several other factors have also been to this page number 1 full bench. The full bench said, when you are acquiring the land of a rustic agriculturist, then collector should put him notice about the remedy available under section 16, under section 18 to claim enhanced compensation, and you can't say that he has expressly waived. So this was the view expressed in the full bench. Like that, there are other issues. In fact, I would say the constitutional bench judgment of the Supreme Court has taken note of only the need to acquire the land for the purpose of public purpose. Public purpose includes that the person who has been deprived of his land also to be remedied properly. Yes, said by Supreme Court in Pondu Ramasamy, government cannot rob Peter and pay to Paul. You cannot acquire the land for a paltry sum, and you cannot drag the farmers before the court for decades together. So this is the exact reality in our country. And in no acquisition, the amount has been paid then and there to the affected farmers. Besides that, there are very limited scope available to the land losers to agitate the acquisition in the earlier proceedings. So these are all the issues have not been taken note of by the Supreme Court, is my view. But incidentally, the Supreme Court in yet another case in 2016, 12 SCC 504, that is much before the Constitution bench, Supreme Court has said that when you are exercising eminent domain power, when compulsory acquisition is made, no question of come and get the compensation, and it is for you to go and pay the compensation. This was the view taken by the Supreme Court. In a compulsory acquisition, you cannot expect the landowners to come and get. On the other hand, you should go and pay the compensation. You should go and give the compensation. This was the view expressed by the Supreme Court. In yet another case, 2016 SCC 258, 2018 16 SCC 258, Supreme Court has said the reading of the provision is very clear, and the plain natural meaning of subsection does not lead to any absurdity or replace the language advisedly used by the legislature. So the word used under section 24(2) is very clear and unambiguous. Therefore, question of giving meaning to or as and it is available in some context in the interpretation. If you read any book on interpretation, you can see sometimes or is given the meaning as and in some places, but not in the case of this nature. So you are depriving the person's livelihood. So the very purpose of section 24(2), because this provision alone has been given retroactive application, not the all other provisions. The rest of the provision, the new act has been given only prospective application. Only this act has given retroactive application, which has taken note of the acquisitions made under the old act also. That is why section 24(1) and 24(2) both start with the word notwithstanding anything contained in this provisions of the act. This is what it started. Similarly, proviso attached to section 24(2) also says that even under the lands acquired under the repealed enactment, if majority of the landowners have not been paid, compensation under the old act, then all of them have to be paid compensation only under the new act. This is what the proviso also reads. Yet another view, 24(2) says that 24(2) nowhere prevents the government from acquiring the land. 24(2) says that if you have not complied with either of these two conditions, then automatically the acquisition comes to an end, but that will not prevent you from acquiring the land under the new act. So right has been given to the executive for the purpose of acquiring the land, even under section 24(2), provided they should invoke the provisions of the new act. This is what the 24(2) has come up for consideration. Then next comes to determination of compensation. If you take section 26 to 28, I would say it is a very benevolent provision to the landowners. Under section 24(1), how the compensation market value has to be determined has been set out. Section 24(1) says market value is nothing but value given under the Stamp Act at the time of registration. So value given under the Stamp Act for respect of the property registered before the sub-registrar office. Then 24(1)(b) also says that average sale price of similar land to be taken note of. Then there are other modalities have been specified. Section 24(1) also deals with the determination of compensation as per the Schedule 1. Schedule 1 says if how the compensation has to be determined. Compensation has to be determined taking note of the sale deeds of the recent proximity. That sale deed must be genuine transaction. That sale deed, lands covered under the sale deed must be of proximate to the date of notification. The lands acquired, lands sold under the sale deed must be in the near vicinity. Lands sold under the sale deed must have similar benefit or as like that of the lands acquired. And these are the comparable sale method has to be adopted for the purpose of determining the compensation. In fact, this position has been deeply considered by the Supreme Court in 2011 8 SCC 91. Supreme Court has said that comparable sales method of valuation is preferable than the other modes of valuation of land, such as capitalization of net income method or expert opinion method. The court can determine the rate of willing purchaser who would pay for the acquired land if it had been sold in the open market. So this is the yardstick to be applied. Even if you see preamble of the new act, which says that compensation to be determined on the basis of a willing buyer and willing purchaser. So this is what the Supreme Court has also said in 2011 8 SCC page number 91. There are various factors to be taken note of for the purpose of determining the compensation. And you would have seen even under the earlier act, 1894 act, how the compensation has to be determined has been elaborately discussed by the Honorable Supreme Court in 2005 4 SCC 789. 2005 4 SCC 789. Only in the said judgment, first time the Supreme Court has adopted a positive and negative method, positive and negative method. A tabular column was also given in this judgment for the purpose of how the amount has to be calculated, how the compensation has to be, the location of the land, proximity to the road, and shape of the land, and developmental activities taken place in the nearby area, and whether any developmental activities requires for the purpose of developing the land, and the special value attached to the land. So these are all the positive factors to be taken note of for the purpose of determining the compensation. Similarly, for negative factors, that is for larger area is acquired, then we can't apply the market value given in respect of the smaller land. That is negative factor, one of the negative factor. Then if the land is situated little interior without any road facility, then these are all the negative factors to be taken note of. So suppose the land is a narrow stripe land and not in proper shape, then that should be taken note of. So these are all the positive and negative factors to be taken note of for the purpose of determining the compensation as held by the Supreme Court in 2005 4 SCC page number 789. But in the present act, 26(2) says that yes, per first schedule of the new act, multiplier has to be adopted. That means in respect of rural lands, 2 multiplier has to be adopted. In respect of urban land, 1 multiplier has to be adopted. Take an example. 1 acre of land was acquired. The market value of the land as on the date of notification was 1 lakh. Then compensation market value of 1 lakh has to be multiplied with the 2 given under the first schedule, which means totally 2 lakhs. Totally 3 lakhs. Then we have to add the damages, if any, cost to the property, namely severance of land. Suppose land is divided into 2 parts, then that has to be taken note of. If during the course of taking possession, if any damage has been caused to the property, that has to be taken note of. Then because of the acquisition, if the landowner has been displaced, or if he has shifted his place of residence or his place of business, then reasonable expenses have to be paid for the purpose of displacing him. So these are all the loss caused to the property that has to be taken note of. So 1 acre for 10 lakhs, then under section 26(2), 2 multiplier has to be adopted. So ultimately the property value comes to 30 lakhs. Then additional compensation has to be paid as per the new act. Then added further, 100% solatium has to be given. Now we have calculated 3 crores, so 30 lakhs. Now by applying this section, this solatium, 100 times of the solatium has to be paid, which means if the land value has been quantified as 30 lakhs under the first schedule, then by adopting the solatium, we have to calculate it as 60 lakhs. Besides that, damage to the property has to be paid, and the interest first 1 year from date of taking possession up to the date of payment 9%, thereafter 12%. This interest has to be paid. So it is almost is a beneficial land for the land losers. So while depriving the land, he will get a good marketable title. In fact, I would say value given under the Stamp Act is only the guideline value. So if this mode of calculation of multiplier is adopted, the land loser will get proper value. That means actual market value available in the open market, he will get it. So this is the one of the best and beneficial provision available under the new act. In fact, there are number. Circular was issued, notification was issued under section 26 by the central government by explaining the position that in respect of rural land, 2 multiplier is permissible. In respect of urban land, 1 multiplier is permissible. So this is the mode of calculation to be made for the purpose of determining the compensation. Then up to 26 to 28 covers the determination of the compensation, quantification of the amount, and calculation of the solatium, additional compensation, interest, everything to be fixed under section 26 to 29 of the land. Solatium is covered under section 30. So whatever the amount quantified under section 26 to 29 will be multiplied as 100 times under the section 30 by way of solatium. So this is the one of the most beneficial provision available under this provision. So ultimately the landowner will get adequate compensation under this new act. That is why if you read the caption of this new act, right to fair compensation and transparency in land acquisition. So it appears that the first time this word has been used for the purpose of giving benefit to the landowners. So the very name of the act would indicate that earlier there was no fair compensation or any transparency in the acquisition proceedings. So this first time the act now has introduced the word right to fair compensation and transparency in the acquisition as well as rehabilitation and resettlement process. So this is what the provisions says about the compensation. Then next comes to rehabilitation and resettlement under section 31 to 42. So the rehabilitation resettlement has to be calculated and quantified as per the schedule 2 and schedule 3. There are 4 schedules. First schedule relating to the multiplier method to be adopted for the purpose of determining the compensation under section 25 to 26 to 30. The schedule number 2 and 3 deals with the rehabilitation resettlement process and the development of infrastructural facilities as per schedule 2 and schedule 3, which comes under section 31 to 42. So here also the same manner as per the scheme prepared earlier under the rehabilitation and resettlement scheme, the amount has to be, the loss has to be quantified, and here allowances are permissible and employment is permissible, and if a person who has been displaced of his house, then a rental of 3,000 is permissible till he gets a proper house, and these are all the benefits available under the rehabilitation and resettlement proceedings. Thereafter, collector has to conduct an inquiry and he has to pass an award. Once collector has passed an award, only after payment of the compensation, the possession can be taken. So section 38 of the act is very clear. Until the payment of compensation, possession cannot be taken. So this benefit was not available earlier. So this is a benefit. Even though section 38 is almost similar to that of section 16 of the earlier act, which clearly says that possession can be taken only after payment of the compensation. And section 39 deals with the payment of additional compensation. Then section 43 to 47 deals with the appointment of arbitrators. That is, arbitrator is a person defined under section 3 of the act. Arbitrator is an officer in the cadre of deputy collector or additional collector who undertakes the process of rehabilitation resettlement process. So that is the officer mentioned. Then comes to establishment of rehabilitation resettlement authorities. So this comes the reference court. Yes, like under section 18 of the old act, we have a provision under the new act for the purpose of referring the matter for enactment of the compensation. Under section 64, reference application has to be made. So the reference application has to be made without, once application has been made, then without further delay, within 30 days, that application has to be forwarded by the collector to the authority concerned, that is Resettlement and Rehabilitation Authority, who is in the cadre of a district judge. So in the state of Tamil Nadu, all the district judges, principal district judges have been nominated as the Rehabilitation and the Resettlement Authority for the purpose of determining the enhanced compensation under section 24, under section 24 and 29 of the Act. So once reference is made, an order has to be passed under section 69. That becomes final. Then appeal remedy is available to the High Court. Then almost the other appeal remedy is available under section 74 to the High Court. Appeal remedy is concerned, only 60 days time is provided for the purpose of filing appeal. 60 plus 60, another 60 day condonable, another 60 days it can be condoned. So appeal can be filed within a period of 60 days, and the court has power to condone for the period of 60 days. Totally 120 days power is given. Under this act, we have to take note of yet another important aspect, namely there is a clear time schedule is given for each and every act to be done. From the date of acquisition till the completion of the process, at every stage, time frame has been fixed. I don't know how far it is possible in a country like India, but however, because you know well, the officials are very slow and they are not prompt enough in doing their official work. Therefore, at each and every stage, this official activities are being stalled for some this file pushing and other reasons. Therefore, I have my own doubt in implementing this new act in view of the tight time schedule given under this act. I will give what are the provisions in which this time schedule is given. Under section 4.2, of the act, social impact assessment study has to be done within a period of 6 months from the date of commencement. So 6 months is the outer time limit has been given. Then after submission of the report, social impact assessment report under section 4, if notification has not been issued within 12 months, under section 11, then that automatically that notification goes. So this is the second provision. Third one, preliminary notifications. The preliminary notification has to be issued within a period of 12 months from the date of submission or acceptance of social impact assessment report. If not, government has power to extend 12 more months, not beyond that. Similarly, section 19 declaration, that is equal to section 6 of the old act, has to be issued within 12 months from the date of issuance of the section 11 notification. Similarly, if no notification, if no declaration under section 19 has been issued within 12 months, then automatically that declaration goes and they have to restart the procedure afresh. Similarly, we have seen time schedule given under section 24(2), that is 5 years. If there was no action taken, no award passed, no person taken, there ends the matter. This was the time schedule given under section 24(2). Then again under section 25, collector has to pass award within a period of 12 months from the date of declaration under section 19. So 12 months from the date of declaration under section 19. Then comes to section 33. If any corrections to be made, it should be made within a period of 6 months, not beyond that. Then comes to section 38. Possession can be taken within a period of 3 months from the date of payment of compensation. Possession has to be taken within 3 months from the date of compensation. Then reference under section 60 to be made within a period of 6 months. Reference has to be made within a period of 6 months. And the award has to be passed within a period of 15 days by the authorities. If award, we are not satisfied with the award, then application has to be given to the collector. That application given to the collector has to be referred to the authority concerned within a period of 30 days under section 64. So the application for reference given to the collector should be referred to the authority concerned, namely district judge, within a period of 30 days. Under section 64(2), time limit for making reference is given. That is 6 weeks from the date of receipt of the notice. 6 weeks from the date of receipt of the notice under section 21. That is for award inquiry. Or 6 months from the date of the award. Whichever first expires should be taken note of for the purpose of determining the limitation. Then comes section 73, redetermination within a period of 3 months of the date of the award. Then appeal remedy under section 74. So if you see the time schedule given at each and every stage, which would show that the very purpose and object of this act is to give a full-fledged acquisition within the time frame, not beyond that. So act itself is a self-contained, even though the similar time limits have been given in various other enactments, and it has been diluted in due course of time. But here the time schedule given under this new act were not available in the old act. So this is another aspect which is in favor of the land losers. If the authorities have failed to fulfill their commitments under this new act, then ultimately the landowner will get benefit out of it. So these are all the main provisions which is available for consideration under the new act. Then next comes to an important provision, that is section 105. 105 of the act specifically says that other than the Land Acquisition Act 1894, earlier we have several other enactments like acquisition for electricity board, that is Electricity Act, the acquisition for Archaeological Department, National Highways. So there are around 13 enactments which are totally excluded from the purview of section 105 of the new act. So the acquisition in respect of those 13 enactments which are listed under Schedule 4 have its own procedure for acquisition, and those lands have not been repealed, and those 13 enactments have been retained intact, and the acquisition under those 13 enactments have nothing to do with the acquisition under this 2013 Act. However, one exception is there, that is 105(3). 105(3) says that if the central government thought it fit to extend the benefit of the provisions relating to compensation, rehabilitation, resettlement, and infrastructure facilities to the enactments mentioned in section 13, enactments mentioned in section 105 of the 4th schedule, it can be done within a period of 1 year from the new act came into force. That means if the benefit of this compensation provision, rehabilitation, resettlement provision have to be given, you have to be extended to those new enactments, it can be done by the legislature within a period of 1 year from the act came into force. Accordingly, the benefit of this act has been extended on 28/8/2015, 28/8/2015 by the Government of India, Ministry of Rural Development, and thereby the determination of compensation has to be made in line with the first schedule. Rehabilitation and resettlement have to be made in line with the second schedule. Infrastructure amenities have to be made in line with the third schedule in respect of the lands acquired for the 13 enactments which are listed in the 4th schedule. Example, this Electricity Act, National Highways Act, Acquisition for Archaeological Department Act. So these are all the enactments have its own procedure for acquisition, but compensation aspect and in the rehabilitation and the resettlement process and infrastructure amenities are concerned, even those enactments are are covered under the provisions of this new act. Chapter 2, 3 and 4 of the new act have been specifically excluded. They have no application to those enactments which are listed in the 4th schedule. So this is what under section 105(3) the amendments have been made. In fact, the very same provision has been challenged before the Madras High Court in 2000. It's a division bench judgment of the Madras High Court. G. Sundar Rajan versus Union of India. G. Sundar Rajan versus Union of India reported in 2018 5 CTC page number 1 equivalent to 2018 7 MLJ 495 equivalent to 2018 5 Law Weekly 113. What was challenged under this judgment is that writ petition was filed to declare the section 105 as well as the 4th schedule of the new act as well as the National Highways Act as null and void. Their case is that you cannot distinguish the acquisition under the National Highways Act as different from the acquisition under the new act. So according to them, it is violative of Article 14 of the Constitution. So this was the arguments advanced under in this said judgment. The division bench of the Madras High Court has taken the view that this special enactments mentioned under 4th schedule is for different public purpose, and the division bench said public purpose mentioned in the 4th schedule should be placed in a higher pedestal than the public purpose mentioned under section 2(1) of the present act. So division bench is very clear that the list of the public purposes defined under the list of 13 enactments have to be given in a little better position than the acquisition made under this act. Therefore, there is the exclusion of those enactments are well within the purview of the legislative competency. This was the view taken by the division bench. There is no illegality or none of the provisions of the Constitution have been violated by excluding those enactments. This was the view taken, and added further, the Supreme Division Bench has gone to the extent of saying that irrespective of the fact that this entry 42 list 3 of the 7th schedule in the concurrent list give power to the both central and state to acquire the land, enact a law for the acquisition. Still, entry 23 of the 7th schedule clearly says that this Parliament has power to legislate a law in respect of the national highways defined therein. So the purpose of national highways is a different project. It is for a linear project, and it is for a different public cause. Therefore, exclusion of the acts listed out in the 4th schedule can't be complained of, is the view ultimately taken by the division bench. Further, Supreme Court has the division bench has taken the view that the landowners have not been deprived of their right to get fair compensation even under those enactments, because the legislature has issued a notification by extending the benefit of the first schedule number 1, 2, 3 to the list of enactments given under the 4th schedule. Therefore, whether land acquired under the new act or under the list of enactments given in the 4th schedule, it makes no difference so far as the compensation is concerned. Therefore, the division bench said there is no illegality under section 105. Simultaneously, yet another issue came up before another division bench, namely, in Tamil Nadu, we have 3 more state enactments, namely acquisition for Harijan welfare, acquisition for industrial welfare, and Tamil Nadu Highways Act. We have National Highways Act 1956. We have another state enactment called Tamil Nadu Highways Act. So there are 3 state enactments. These 3 enactments have to go automatically once the state enactment have come into force. You know well, under Article 254 of the Constitution, 254(2) of the Constitution says that when the central legislature have enacted a new law, then that law will override the law of the state enactment which was already there in force, and to the extent of the repugnancy. If any of the state enactments are repugnant to the central enactment newly made, then the state enactment has to give a way to the central enactment, and the state enactment will become a void one under Article 254 Clause 2 of the Constitution. While so, the state Tamil Nadu has amended Article 105 and added 105A, and that amendment was placed before the Honorable President for getting assent. Assent was given, and Section 105A was introduced, which protects the acquisitions made under the 3 enactments. That was put under challenge before the division bench. The Madras High Court in Caritas, Caritas, Caritas India versus Union of India, reported in 2019 4 CTC 737, 2019 4 CTC 737, equivalent to 2019 4 Law Weekly, 2019 4 Law Weekly 200, equivalent to 2019 5 MLJ 641, 2019 5 MLJ 641, held that 105A introduced by the state enactment is ultra vires, and it was struck down on the ground that this state enactment, the state amendment is directly hit by Article 254(2) of the Constitution. That is one aspect of the matter. 2, the Section 113 of the new Act empowers the government to remove the difficulties, if any. Therefore, the Union of Government has issued a notification extending the benefit of certain provisions, namely the compensation, rehabilitation, resettlement, and infrastructural amenities to the new to the other enactments also. Therefore, the newly inserted amendment is per se illegal, is the view taken by the Honorable Division Bench. In fact, the Honorable Division Bench has taken note of 9 judges bench judgment of Constitutional Bench judgment of the Supreme Court reported in 1974 2 SCC 402, 1974 2 SCC 402, and Supreme Court has held that if a state act is totally repugnant to the central act which has been introduced later, then the state act has to go. But no doubt state has power to reenact a law. But while reenacting a law, the assent of the Honorable President has to be obtained. At the time of submitting the records for the purpose of getting assent, the state legislature has to place the existing central act and the relevant provision which are repugnant to the said central act. If this has not been pointed out, then it is totally in violation of Article 254(2). This was the view taken by Division Bench, and this view was taken by following the Constitutional Bench judgment of the Supreme Court in 1974 2 SCC 402. Then yet another judgment 2012 7 SCC 106. These are all judgments have been followed by the Honorable Supreme Court and held that even though the acquisition power is available to both state and central, such an amendment can't be introduced in violation of Article 254. This was the view taken. Then ultimately, this new act has been in force for the past nearly for the past 5 years, and so far, to my knowledge, no acquisition has taken place under this new act. Only when acquisition has taken place under the new act, then only we have to test it before the court of law, and judgments are yet to come under this new act. Incidentally, let me point out a few provisions of the National Highways Act. The National Highways Act, as we have seen, has been specifically excluded under 4th schedule of the new act. There are 4 schedules. So 4th schedule gives a list of enactments which are excluded from the purview of the new act. So National Highways is one of the act which has been excluded. The National Highways Act was enacted in the year 1956. When the act came into force, there was no provision for acquisition. So, 1956 Act did not contain any provision for acquisition. In fact, only in 1997, exactly on 24/1/1997, Section 3A, 3 capital A to 3 capital J, 3 capital A to 3 capital J were inserted by way of amendment, giving power to the National Highways, National Highways Act to acquire the land for the purpose of highways. This amendment was brought in, as I said, pursuant to the power given under entry 23 of the Union List of the 7th schedule, which gives power to the Parliament to acquire the land exclusively for the purpose of development of national highways. That is why this has been specifically excluded from the purview of the new act. So this new National Highways Act has its own unique provisions. Even though issuing notice, hearing the objections, conducting survey, and passing award are almost similar to that of the other enactments. It has some special features also. In this enactment, section 3G, specifically National Highways Act section 3G specifically deals with the determination of the compensation payable to the landowners. So this provision, this 3G, deals with how the amount to be determined by the competent authority, how the amount should be paid to the right of user. Some may have easement right over the property. It should be given 10% of the land value, market value, 10% of the market value to the person who has been deprived of his right of easement over the property, and public notice to be given, and compensation for severance should be given, and opportunities, everything is provided. Once an award has been passed by the authority, namely, and not like in other enactments. Here authority has been specifically mentioned, namely arbitrator. The district collector of every district is authorized to act as an arbitrator under section 3G5 of the National Highways Act, to act as an arbitrator. After the award passed by the arbitrator, namely the district collector, if anyone have any grievance against the quantum of compensation, he can approach he can challenge that award passed by the arbitrator under the provisions of the Arbitration Act, under section 34 of the Arbitration Conciliation Act 1996, before the district collector, the district court. And you know well, section 34, the scope of adjudication, section 34 of the arbitration can be exercised within the 4 corners of the said section. It can't act as an appellate authority. The power under section 34 is not like an appellate authority. So the evidence can't be evaluated, evidence can't be reappreciated, and the court cannot relook the entire matter afresh for the purpose of determining the validity of the award challenged under section 34 of the Arbitration Conciliation Act against the award passed under section 3G5 of the National Highways Act. That means whatever the amount quantified by the arbitrator will become final. So this was the view prevailing all along. Fortunately, the division bench of the Madras High Court recently reported on 13 to 2020, it is a judgment of by the project director, National Highways Authority versus M. Vijayalakshmi. The project director, National Highways Authority versus Vijayalakshmi. Case number CMA MD 560 of 2018. It is yet to be reported. The division bench has taken the view that the power of the power under section 34 has to be interpreted in the light of the powers given under the Highways Act, because Highways Act says that subject to section 33G6, section 3G6 that says that subject to the provisions of this act, the powers of section powers given under the Arbitration Conciliation Act 1996 has to be invoked. So the word subject to the provisions of this act as defined under section 3G6 has been interpreted by the division bench of Madras High Court to the extent that the power can be exercised to reappreciate the evidence for the purpose of fixing the proper compensation. So the decisions which are reported in respect of section 34 of the Arbitration Act cannot be fit in for the purpose of dismissing the petition original applications filed against the award passed by the arbitrator under section 3G5 of the Highways Act. So it is a thought breaking judgment which gives enormous power even for the court to grant enhanced compensation by going into the materials afresh as like appellate authority for the purpose of giving proper compensation. So ultimately, payment of just compensation is the hallmark of justice in respect of land acquisition cases are concerned. Therefore, the division bench taken the view that you cannot shrink the responsibility given under section 34 in respect of the challenge made to the award passed under section 3G5 of the National Highways Act. So this is what the view taken by the division bench of the Madras High Court. Then almost similar provisions are available. Now recently, section 3G of the National Highways Act said that the provisions of the 1894 Act has no application. So this provision has been struck down by the Honorable Supreme Court in 2019 9 SCC 304. 2019 9 SCC 304. So now the Supreme Court has struck down the section 3J, which excludes the application of the Land Acquisition Act 1894, which was in force all along from 1997 to at least from 1997 to 1/1/2014. Now it is no longer available and the provision has been struck down. So these are all the main provisions available under the land acquisition laws. With this, I want to, because I don't want to multiply more and more judgments which are available only under the earlier enactment. So the leading decisions which I have given are very useful for the purpose of even applying whenever the challenge made to the new act. With this, I want to conclude, sir. If any questions are available, I am prepared to answer, sir. Thank you very much.
Mr. Manokaran, as usual, it was spot on. I don't think that the way you took everyone for 1 hour 45 minutes, it only speaks volume, and you have covered every aspect, including as we had requested you, that NHI is one of the aspects which actually refers to the effect that as to how it could be assimilated. You have referred to the same thing judgment and then this Madras High Court judgment. Because invariably, one aspect, as you rightly said, that all the judges generally believe that, or lawyers also for that matter, have always been taking that section 34 scope even in the arbitration matters as referred under the NHI, is to the effect that the scope under section 34, what is restricted and under the Arbitration Act, has to be considered.
Yes.
But that insights, and invariably all the insights as to how Article 244, 254, etc. has to be appropriate. The session was quite engaging, and when we had requested Justice S.D. Anand to join with us, he said that land acquisition is a slightly different subject. I have a good flavor towards the constitutional matters. But the way he was also spellbound, like we all of us, only shows the volume of knowledge you have decimated not only on this webinar but the other webinars. Those who have stayed, have connected for the first time, they can also see all these Mr. Manokaran's and all other webinars on our YouTube channel of Beyond Law CLC. In fact, we have done more than 100. We are touching 103. They can be seen there. We have questions posted on the.
Sir, before that, I want to. I missed one more important aspect. That is the right of the subsequent purchases after the notification. There are 2 or 3 leading decisions on that aspect. You know well that any purchase made after the notification has been issued, it has no effect at all. So the purchaser can have only the compensation. The subsequent purchasers have no right to question the notification. They have no right to question the notification. They can only get the compensation which is payable to the landowner. So that is the only remedy available. This position has been settled by the three judges bench of the Honorable Supreme Court in 2015, 1 SEC page number 1. 2015, 1 SEC page number 1. And further reiterated in 2017, 6 SEC 751. 2017, 6 SEC 751. So only subsequent purchasers can get the compensation and they cannot question the notification. In fact, very recently, in 2019, 10 SEC 229, 2019, 10 SEC 229, Supreme Court has gone to the extent of saying that the subsequent sale is per se void. So, question of giving audience to the subsequent purchaser doesn't arise. So, the Supreme Court has one step ahead and said that it is sale in itself is a void one. So, this is the present position. Finally, regarding this 11A of the stay, the earlier act, you know well, if no award has been passed with the time frame fixed, automatically the acquisition gets lapsed. So this came up for consideration before the Supreme Court in 2018 7 SEC 763. 2018 7 SEC 763. Supreme Court has given few guidelines. The crux of the guidelines is that if the scheme of acquisition is stayed at the instance of some of the land owners, if a portion of the stay has been granted in respect of a portion of the land that would operate against all, then it has to be treated as if stay granted in respect of the entire lands are concerned. So this was the view expressed very recently. Therefore, any kind of orders would be an initiative action on the part of the authorities to proceed further. This is what the Supreme Court has held. So even a stay has been granted in respect of a portion of the land, then if the authorities have been, hands of the authorities have been tied to proceed against other portions, that would be treated as a stay in operation under section 11A of the Act. So this is what the right given to the subsequent purchaser. With this, I conclude, sir. Yes, Mr. Vikas.
In fact, my remote control also goes at some other places.
No problem.
So that there's no audience. For all those participants who have not connected us on the WhatsApp group, we have shared the notes what Mr. Manokaran has shared. And insofar as the other notes of the previous session is concerned, due to the lockdown, the notes could not be shared. That's what Mr. Manokaran told, that he had the steno wasn't there, and it's quite understandable. So the notes otherwise can be recorded after noting down the uploading and downloading the YouTube session. But we will be sharing those notes. Meanwhile, I will be taking questions.
Yes, sir.
This is by Dinesh. What was the main reason to Article 31 being fundamental right being shifted to Article 300A as a legal right?
Sir,
what is your take?
So if it is a fundamental right, you know well that the legislature or even executive can't interfere with that right. So that is why the right which was there as a fundamental right under Article 19(1)(f) and 31 have been completely removed by way of amendment, 44th amendment dated 26/1979. So if it is a fundamental right, then it would go against the acquisition. So we can easily prevent the acquisition of the land. Once the right has been recognized as a fundamental right, right to hold, right to purchase, right to alienate the property is a fundamental right, then such right can't be intruded by exercising power of eminent domain. Therefore, the legislature thought that this should be removed. So this they have done it 26 years after the constitution came into force.
Okay. This is by Devika. If in a proposition, while the process of social impact assessment was going on the nature of land was agriculture, but subsequent to the publication of report, but prior to the preliminary notification, the landowner obtains the certificate of CLU. What will be the position then?
Certificate of
Change of land use, CLU.
No, sir.
Change of land use from agriculture to, obviously it should have been an industrial. That's what I can note.
Oh, change of usage you are referring, sir.
Yes, in northern area we say CLU, change of land use.
So what is relevant is what is available as on the date of preparation of the social assessment report is relevant for the purpose of deciding the factor, but that report has to be examined by the expert committee. So the expert committee includes the persons from various fields, namely experts in the field, in the agriculture field, experts from the local body, and others experts mentioned in section 7 have to analyze the report given. Then after their opinion, it will be placed again before the collector, then commissioner, then to the government. So in between, any development has taken place that can be taken note of for the purpose of determining compensation, because you know well that the land value has to be determined only on
the tenant is doing something. I'm just asking him to stop, otherwise there will be sound. Yes, Vishal Vadile. If an acquisition government has already shared which all land will be acquired, and the landowner who has an agricultural land, now knowing the fact that the government will pay a good amount, so the landowner who was about to be compensated.
So please repeat, sir.
I'm just saying, actually, yes. If in an acquisition government has already shared which all land will be required, and the landowner who has an agricultural land, now knowing that the fact that the government will pay a good amount, so the landowner who was about to be compensated by an amount, now after converting the land into a non-agricultural land, will be getting 5x amount. Is this a loophole where the administration have failed to take a look into it?
Sir, compensation has to be determined on the basis of several factors mentioned in section 24 to 29. Compensation is not being determined on the basis of any single factor. So not only the land usage, various other factors have to be taken note of for the purpose of acquiring the land, namely comparative sale method, the proximity, land location, facilities available, shape of the land, and the nature of the crops cultivated. And there are various other aspects have to be taken note of for the purpose of considering quantifying the compensation, determining the compensation. In this case, even though the land was under one usage at the time of social impact assessment report, and subsequently if it has been converted, then what the nature of the land which is available as on the date of issuance of the notification under section 11 alone is relevant for the purpose of determining the compensation. And you know well, there are modalities prescribed for the purpose of determining positive and negative factors in fixing the compensation. So before acquisition, in order before as on the date of issuance of notification, we have to take note of various comparable sale deeds. All will be put together for the purpose of determining the compensation. So the land usage is one of the change of land use is one of the criteria for the purpose of quantifying, not the sole criteria. So it requires elaborate procedure. That is the position, sir.
This invariably were answered. Will new Land Acquisition Act apply to the appeals under Section 34 under the NHI which are pending in the court?
Sir, that 24. The
34. No, he's not discussing about indoor development. He's referring, will new Land Acquisition Act apply to appeals under Section 34 under NHI which are pending in the court?
Sir, 24 24 is considered, you know well that it is only in respect of compensation.
He's asking about Section 34 of the NHI. That is actually is not proper. He's trying to ask whether the Arbitration Act Section 34, the correlation where we say that the appeal, the objection under Section 34, probably, because now he's not written the name, or he this OPPO F9 should.
Sir, this
revisit his question.
Benefit under the new act in respect of compensation payable to the National Highways Act has been introduced only on 28/8/2015 by way of a notification number SO 2368E. So, Government of India Rural Development, Ministry of Rural Development, by order dated 28/8/2015 has introduced this notification, by which the benefit available under this new act has been extended to the National Highways Act. So, if any acquisition made on or after this 28/8/2015, then we can extend the provisions of this new act to the acquisition made under the Highways Act also. There is no difficulty at all, sir.
I don't think there's much question. Yes. Does New Land Acquisition Act 2013 apply to the acquisition under the NHI Act or the State Highway Acts?
No, sir. No, sir. No, it is not applicable to the State Highways Act. In fact, this was specifically the moment new act came into force, automatically State Highways Act goes. So, in fact, because of that implication, since the new State Highways Act has been indirectly repealed by way of Section 105, the state Tamil Nadu has introduced a new act that was struck down. New provision has been struck down by the division bench. I have already stated 2019 4 Law Weekly 200. 2019 4 Law Weekly 200 equivalent to 2019 5 MLJ 641. So the moment State Act came into force on 1/1/2014, the state enactments have gone. State Highways Act has gone. It has no application at all, sir.
The questions will continue to keep on pouring, but since the participants are knowing this fact, and as well as you, that ultimately we have to draw the line somewhere. Before I will come for the vote of thanks, I will ask Justice S.D. Anand, who is quite pleased, his smile tells it all, to sum up in his own way, because as a judge, we have seen him. He has his own style of giving the summing up, or his judgments used to always be short, crisp, as we always talk of drafting. So over to Justice S.D. Anand, who has been the former judge from Punjab Haryana High Court.
I must congratulate Mr. Manokaran for a very, very, very elaborate and distilled discussion about not only the provisions but also the applicable law. I really do not know whether the competent administrative authorities would like to play this tape in the judicial academies for the benefit of the judicial officers who have to deal with these land acquisition matters. This would be beneficial not only for the judicial officers, even for the lawyers. I have my undiluted concurrence to the reservations indicated by the worthy speaker about whether the provisions would be conscientiously, meticulously complied with. The provisions are very beneficial to the people who are left without their land. Basically, it was mindless acquisition, which ultimately compelled the apex court to come in by way of an appropriate mention in the writ or SLP that then these amendments came in. If the officers in the administration, each one of them, at every hierarchical level, if they do it competently, if they do it with dedication, I think the pain which would arise to which the people rendered endless will be substantially reduced. But I do have my very serious reservations about that. It was very illuminating, Mr. Manokaran. I'm very happy. I'm very happy that
Thank you.
so grateful. Thank you so much. Thank you so much.
Thank you, sir. And on behalf of Beyond Law CLC, we would like to inform, though invariably we are having sessions at 11 or 4 or 5, but tomorrow the webinar would be at 5. And the topic, and tomorrow we have a tie-up with National Law University, Sonipat. We are their knowledge partners. Tomorrow the webinar is Be a Cyber Sathi, Cyber Crimes and You, by the speaker is N.S. Napinai, who is an advocate and who has established her name in the not only in the cyber law but on constitutional law. Key areas of practice are at Madras, Bombay, and the Supreme Court. So do stay connected with us. Tomorrow, we promise you that it will be an vilifying session. So everyone, stay safe, stay connected and healthy. And Mr. Manokaran, on behalf of Beyond Law CLC and all those participants who have been engaged with us on the platform as well as on the live on the Facebook, we are thankful to you for giving the insightful session. It was really engaging, as well as sarcastic. Words cannot express the way you have expressed the knowledge. We are all full of gratitude the way you have expressed it. Thank you.
Thank you very much, sir.
Thank you.